Progress for Ireland's offshore energy sector. The Maritime Area Planning Bill is ready to go. The Maritime Area Planning Bill has been published along with the National Marine Planning Framework. Ireland has committed to meeting 70% of electricity demand from renewable sources by 2030. Offshore wind is earmarked to contribute 5 WG of generation capacity to this target, the construction of which need to be facilitated by a streamlined consenting regime. The Maritime Area Planning Bill has been keenly awaited by energy sector stakeholders eager for the clarity needed to get going. What does the bill tell us about how offshore project will be progressed? The bill reshapes the consenting regime by providing that two-spirit consent will be required for the development of offshore renewable energy projects. One consent is needed to occupy the maritime area. A maritime area consent (MAC) and another to allow development of that area, a development permission. MAC must be obtained first, following which the development permission can be sought under the Planning and Development Act 2000, amendment of which is provided for in the bill. The Maritime Area Regulatory Authority (MARA) will be established and will be responsible for the granting of MAC license discussed further and the enforcement of the new regulatory regime. The Minister for Housing, Local Government and Heritage, the Minister will decide on the establishment day for the MARA and indicated in April 2021 the establishment was in train and arriving shortly. And Board Plenella will be responsible for the grant of the development consent of the foreshore. What does the bill say about projects that have already secured a foreshore authorization, whether a lease or license under existing legislation? Some projects already have a foreshore lease or license under the Foreshore Act 1933. The bill provides that the holder of a foreshore authorization doesn't need to apply for MAC until its foreshore authorization is going to expire or unless it wishes to amend its currently authorized activity or occupation of the maritime area. An application for MAC can be made at any time before the expiration of the foreshore authorization. A foreshore authorization will not expire until the holder of the lease or license has surrendered the authorization and has been granted a MAC or the expiration date on the authorization is reached. The bill makes provision for special MAC cases, which are projects where the proposed maritime zoo sheds involve the use of wind to produce offshore renewable energy. To qualify as a special MAC case, project must have been the subject of an application for a foreshore authorization made but not determined, abandoned, or withdrawn before 31 December 2019. The subject of a foreshore authorization or the subject of a valid connection agreement or confirmation of eligibility to receive a connection before 31 December 2019. Projects that fall into the category of special MAC cases may make MAC application to the Minister once the bill is enacted and before the establishment of the MARA. It seemed that a separate application to MARA would have to be made for any extended area beyond that which is included in the foreshore authorization or application. What is the situation for projects that do not fall into the category for special MAC cases? Such projects cannot avail of first mover advantage by applying to the Minister. They must wait for the establishment of the MARA and submit their MAC application to the MARA. Given that scheduled auction under the Renewable Electricity Support Scheme (RESS) are due to incorporate offshore wind in early 2022 and processing rounds are ongoing under the Electricity Connection Policy (ACP), it is critical that projects have a line of sight of the time scale within which they will be able to identify with some certainty the location of the maritime area in which they can develop and the conditions that will apply to development. What is the levy framework? The bill provides that the mayor must establish a levy framework under which MAZ holders will pay a levy for the use or potential use of the part of the maritime area that is the subject of the MAZ. The levy framework may provide, for example, for different levies to be paid for different classes or MAZ for levies to be paid on the occurrence of specified event or for the circumstance when a levy may be a nil or token amount. The criteria that the mayor must have regard to when establishing the levy framework is set out in Section 88 of the bill. The criteria includes factors such as the likely profit to be gained by the MAZ holder, the likely public benefit to be gained from a class of maritime usage for which MAZ may be granted, and the marine planning policy statement which the minister is required to prepare and publish in accordance with Section 6. MAZ cannot be granted until the applicant has been informed of the levies that it will be required to pay. On what basis is a MAZ granted? The bill set out the criteria that the mayor or the minister must have regard to when deciding a MAZ application. The criteria include the nature, scope, and duration of the occupation of the maritime area, whether the proposed maritime usage is in the public interest, whether the applicant is a fit and proper person, the National Marine Planning Framework, the level of preparatory work already undertaken in relation to the project, and the level of stakeholder engagement in relation to the project. The mayor is required to give a decision on an application for MAZ, including reason for any refusal, within 90 days of determining that an application is valid. Importantly, MERA will not carry out an environmental impact assessment screening or appropriate assessment screening when deciding MAZ application. Where the MERA grants only part of the MAZ SOC, grants in with condition, or refuse to grant it, it must provide a reason for its decision to the applicant. The MERA will state whether or not the MAZ is for the exclusive use of the maritime area identified. Exclusive use may be granted, but may be contingent on circumstances arising after the MAZ is granted. What happens if there is more than one application for the same area? The mayor may use a competitive process to determine which applicant will be granted MAZ in circumstances where there are two or more applications for the same area of the maritime area, and where the mayor considers that only one MAZ can be granted for that area. Thank you.